Good evening, everyone. My name is Ericka Hinong, and I'm here to discuss under Chapter 4 of Extinguishment of Obligations, the fourth special forms of payment, Tender of Payment and Consignation, Article 1256 to 1261. So, let us go to the first slide. Article 1256. If the creditor to whom tender of payment has been made refuses, without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. But before that, let us familiarize ourselves muna sa mga terms na tender of payment and consignation. Tender of payment, the act on the part of the debtor of offering to the creditor the thing or amount due. The debtor must show that he has in his possession the thing or money to be delivered at the time of the offer. So, if it is a monetary obligation, yun yung pag-offer na ibigay yung pera o bayad. If it is an obligation to give something, pagbigay ng object mismo. Tender of payment is the act of offering. It's a preparatory act for consignation. Next, consignation. The act of depositing the thing or amount due with the proper court when the creditor does not desire or refuses to accept payment or cannot receive it, after complying with the formalities required by law. So, after mo mag-tender ng payment, the creditor cannot accept or refuses to accept payment, then what should you do? Ikaw yung debtor, nagbayad ka na para matapos na yung obligation mo pero ayaw tanggapin. You have an option to consign it with the proper authority. I-deposit mo doon sa court ang pera or bagay para ma-extinguish ang obligation mo. Of course, this is done after complying with the formalities required by law. You have to file a case for that matter. Next, it is always judicial and it generally requires a prior tender of payment, which is by its very nature extrajudicial. So, dito, tender is required before you can file an action for consignation. That's why the nature of tender is extrajudicial and consignation is always judicial. So, dito na tayo sa talagang meaning ng Article 1256. If the creditor to whom tender of payment has been made refuses, without just cause to accept it, the debtor shall be released from the responsibility by the consignation of the thing or sum due. So, dito sa Article 12, sa Tender of Payment and Consignation, meron tayong general rule. There can be no consignation without a valid tender of payment. So, the first thing you must remember about tender of payment and consignation is that they go hand in hand. Hindi ka pwedeng magkaroon ng tender of payment tapos hindi susunod ang consignation. The obligation will not be extinguished. So, pagka-tender mo, you have to proceed with consignation. Consignation, before you can do it, there must be a prior tender unless tender is excused, which is madidiscuss natin mamaya. So, these are the examples. Number 1, D owes C a sum of money. On the due date of the obligation, D offers to pay the obligation but C refuses to accept the payment without any justifiable reason. So in this case, this obligation will not be extinguished until he has made a valid consignation. So anong gagawin ni D? Pupunta siya sa court to deposit the money and this is called consignation. Take note din pala na dapat yung refusal to accept ni C or ni creditor is not justified. For example, itong si C, the creditor, ayaw niyang tanggapin yung payment for no reason at all. Pero if may valid ground si creditor para tanggihan ang bayad ni debtor, the refusal is justified so di magiging valid ang consignation. And in the next slide, madidiscuss natin yung requisites of a valid tender of payment. Number 2, D entered into a contract with C. D is given the right to cancel the contract upon payment of 1,000 to C. So in this case, D has no existing debt to C. The amount of 1,000 is not owed by D, being merely the consideration for the exercise of his right to cancel the contract. Hence, consignation of the 1,000 is not necessary. Tender of payment in good faith is sufficient to entitle D to cancellation. Number 3. For failing to pay rents for 3 months or lessor demanded that E, lessee, pay the back rentals and vacate the premises. Subsequently, R filed a complaint for unlawful detainer. E contends that R refused to accept the rents. So, the failure of R to collect or his refusal to accept the rentals is not a valid defense. To be released from responsibility, the debtor should consign the thing or sum due. The belated payment of the back rentals by E does not automatically restore the contract of lease without R's consent. So next, ito na yung requisites of a valid tender of payment. So letter A, tender of payment must comply with the rules on payment, meaning it must be in a legal tender, must include whatever interest. The obligation must be already due. Thus, a check, whether it's a manager's check or ordinary check, is not a legal tender, and an offer of a check in payment of a debt is not a valid tender and may be refused by the creditor. B. It must be unconditional and for the whole amount. So, if made with conditions but accepted with the creditor without protest, the creditor cannot later on prescribe the terms for the validity of the acceptance which he had already made. And letter C, it must be actually made. The manifestation of a desire or intention to pay is not enough. So, ito, ibigay mo yung pera or thing. Hindi sapat na desire or intention mo lang ang pagbayad, kaya it must be actually made. Remember also, na ang tender of payment must be proved by the debtor in the proper case. Kailangan niyang i-prove sa court na nagkaroon ng valid tender of payment, pero may mga cases na di kailangan ng tender of payment at pwede ng diretsong consignation. So, dito na yun sa next slide. In consignation alone shall produce the same effect in the following cases. So, tender of payment is not required in the following instances enumerated in the second paragraph of Article 1256. So, number 1, when the creditor is absent or unknown or does not appear at the place of payment. So, wala si creditor, di nagpakita. So, walang tender of payment. Number 2, when he is incapacitated to receive the payment at the time it is due. So, kapag siya ay walang kakayahang tanggapin ang bayad sa oras na dapat magbayad. Remember, payment to an incapacitated person is void, so bakit ka magre-risk? So, kahit mag-tender ka, di naman maiintindihan kasi incapacitated siya. So, diretso ka na sa court. Applicable lang to if walang legal representative sa incapacitated creditor na pwedeng tumanggap sa tender of payment. Kapag meron naman at alam ni debtor like minor, meron naman parents pwedeng sa kanila ibigay. Not necessarily na consignation. Pero kapag nagbayad ka at tinanggihan ng parents or ng legal representative, ay pwede mo i-consign. Number 3, when, without just cause, he refuses to give a receipt. So, ayaw magbigay ng resibo. Kapag ganon, pwede mo i-consign na lang si debtor sa court ang bayad niya. And number 4, when 2 or more persons claim the same right to collect. So, marami nagka-claim 2 or more persons daw. Dito naman, di mo alam kung sino babayaran sa kanila. Sino ang nagsasabi ng totoo na sa kanya dapat magbayad o ibigay ang bagay na yon. So, dahil marami nagka-claim, ang gawin mo consignation. Pumunta ka sa court, tapos let them settle their claims na kung sino ang manalo sa kanila, at least sa kanila mapupunta. And last one is, when the title of the obligation has been lost. Meaning, yung written document na wala. So, much better i-deposit mo na lang sa court ang bayad. So, question, paano pala if after nag-tender ng payment, which the creditor refused without justifiable cause, ang tagal pa before consignation was made by the debtor. Say, after ilang years pa bago niya ginawa ang consignation. Ang mangyayari daw, yung interest should run. So, palaki ng palaki yun. Next, Article 1257. In order that the consignation of the thing or due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. So, dito naman, para ma-release daw si debtor or obligor sa kanyang obligation, dapat mayroong prior notice to persons interested. So, sino ba itong mga persons interested? Ito yung mga guarantors, mortgagees, solidary debtors, and solidary creditors. So, if walang prior notice sa kanila, ang consignation ay void, hindi valid. So, but before the second paragraph, proceed muna tayo sa requisites of a valid consignation. So, in order that the debtor may be released from his obligation by the consignation of the thing or sum due, the following requisites must be observed. Number 1. Existence of a valid debt which is due. Article 1256, paragraph 1. So, check natin if meron bang valid debt. Hindi rin void ang utang. And number 2, tender of payment by the debtor and refusal without justifiable reason by the creditor to accept it. So, if required ang tender, dapat valid tender of payment. Yung ino-offer na bayad is legal tender. In-offer mo bayaran yung creditor tapos walang justifiable reason, hindi in-accept unless tender is excused. So, wala ng tender, pwede dumiretso ka na rin sa consignation. Number 3. Previous notice of consignation to persons interested in the fulfillment of the obligation. So, dito is before the deposit. The consignation must be announced to the persons interested. Without such notice, the consignation as a payment is void. So, purpose nito is to give the creditor, the persons interested a chance to reconsider yung previous refusal, and so, may iiwasan yung litigation na umabot pa talaga sa court. Number 4, consignation of the thing or sum due. So, ito na yung actual consignation of the thing or sum due. And number 5, subsequent notice of consignation made to the interested parties. So, ito yung kapag na-file mo na talaga. So, usually, the subsequent notice of consignation is paid by the court. So, yung court will send letter to the creditor. Article 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. So, consignation must be with proper judicial authority. Consignation is necessary to effect payment. As tender of payment precedes consignation, the tender must be proved by the debtor in the proper case. In other cases, when tender is not required, only prior of notice to interested persons of the consignation needs to be proved. Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. So, creditor bears expenses of consignation. The consignation is made necessary because of the fault or unjust refusal of the creditor to accept payment. That being the case, it is just the expenses should be charged against the creditor. This is also the reason why we have previous notice of consignation. Kasi baka magbago pa yung isip ng creditor, baka tanggapin niya na ang pera. Because remember, in consignation, once it is deposited in the court, the creditor will bear the expenses. So, bago magbago yung isip niya, i-notify mo muna siya bago ka pumunta sa court at mag-deposit ng pera doon. So, if consignation is not properly made, or if the debtor withdraws payment, obviously, expenses are chargeable to the debtor. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Dito sa Article 1260, sinasagot natin yung tanong na what is the effect once the consignation has been duly made? Ano ba yung epekto kapag na-declare na yung consignation has been duly made? The debtor may ask the judge the cancellation of the obligation after due hearing and a judgment that all the requisites of consignation have been met and this operates as a valid payment. Yung running of interest din is suspended, so pwede na i-cancel ang obligation niya. Dito naman sa second paragraph, the debtor may withdraw the thing or sum consigned as a matter of right before the creditor has accepted the consignation or before there is a judicial declaration that the consignation has been properly made. After all, right niya yun eh. Kasi hindi pa naman binibigay sa creditor yun. Hindi pa tinatanggap ng creditor at wala pa rin naman judgment ang court. In such case, the obligation will continue and all expenses are paid by the debtor. Kasi winidraw naman niya ang kanyang payment deposited to court, so walang valid extinguishment of obligation. Last article, Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same, he shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. So, pwedeng i-withdraw ang pera if there is a decree that the consignation is proper but there must be authority from the creditor. Now, if the creditor authorizes yung withdrawal of payment, syempre, pwede na i-withdraw ng debtor yan. But the creditor will lose all his preferences over the thing or the money deposited to the court. Also, co-debtors, guarantors, and sureties will be released from the obligation. So, these are the examples. Number 1, D is indebted to C in the sum of 10,000 with G as the guarantor. On the due date of the obligation, D offered payment but C refused to accept the same. So, D made a consignation. Subsequently, D withdrew the deposit after securing the consent of C. So, dito, D made a proper consignation. And so, after the court canceled the obligation, D withdrew the deposit after securing the consent of C. So, under Article 1261, C shall lose whatever preference he may have over the amount, and G, the guarantor, shall be released. Number 2. If, in the example given, D and G are solidarily liable to C, G is released only from his solidary liability, but he is still liable to C for 5,000, his share in the obligation. So, dito, si D and G ay solidarily liable to C. Yes, released na si G from his solidary liability, but still, he has his share of obligation pa rin, which is 5,000, kalahati ng 10,000 na utang nila. So, that's it for Articles 1256 to 1261, Tender of Payment and Consignation. Thank you for listening.